Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
Before we dive into today's episode of the podcast, I wanted to let you know that coming up in June, we are going to be doing a special 5-part series on the podcast on attacking the results of breath testing. Really, to begin with, we're going to spend a couple of episodes talking with toxicology expert Andy Ewens from Ewens Toxicology. He is an expert on toxicology. He's going to help us understand the science behind breath testing and get a better understanding of the science specifically utilized kind of in the framework of the ECIR2 device. We are then going to follow up with several incredible attorneys, James Nisi, Matthew Davenport, and Stephen Lindsay, to talk about different kind of methods of understanding the science behind breath testing, as well as how to effectively attack this start to finish on your case. So James Nisi, we're going to talk about a couple of different ways of using kind of the math that is used in breath testing to actually convey to the jury what's going on and why this is important in your particular case. With Matthew Davenport, we're going to talk about state versus Neyron, state versus Simmons, and kind of what does it mean, this language presume impaired, and some of the implications on that. And then finally, we will close out the 5-part series with Steve Lindsay giving us some helpful information on attacking the breath testing device in closing arguments. So I just wanted to put that on your radar. It's going to be a really fun and I think informational series coming up in June. So make sure that you tune into that. And with that, we'll go ahead and dive into today's episode. Hello, fellow freedom fighters, and welcome to episode 55 of the NC DWI Guy podcast. Today on the episode, we are talking about the seminal North Carolina Supreme Court case of State versus Knoll. State versus Knoll, big stuff, big legal issues on today's podcast, talking about the 3 cases within State versus Knoll, State versus Knoll, State versus Warren, and State versus Hicks. We're also going to be talking about the statutes that are connected with a Knoll argument. So a lot to cover. This is going to be a very legalese podcast. We're going to get into the weeds on State versus Knoll. So very excited about today's episode. We've already talked about on the podcast the witness issues that kind of connect to breath testing rights. So on episode 4, we talked about State versus Ferguson and State versus Hatley, and using those cases to attack a situation, factual situation, where your client has been denied the right to contact an attorney or have a witness present during breath testing. We are talking about witness rights again in today's episode, but it is really a denial of release. So a separate legal issue than denial of a witness during breath testing, which we previously talked about on the podcast on episode 4. So today we're going to kind of go through the legal framework of State versus Knoll. We're going to talk about the specific facts that were within the Knoll cases. And then on next episode's podcast, episode 56, we're going to have attorney Nathan Earwood on the podcast, who is going to kind of walk through practically how to make these cases work in the courtroom, how he has been successful in his practice. Nathan has won a number of cases based on State versus Knoll. And Nathan and I recently had cases that were dismissed on the same day before even a hearing because of kind of the flagrant violations presented in the Knoll line of cases. We both had cases dismissed, he in Swain County and I in Clay County on the same day. And so that's kind of what led to this discussion, was having kind of spoken with him that morning about our cases. It was kind of like, we need to kind of bring this information out so that people can understand what the legal framework behind the State versus Knoll argument looks like. So in terms of just diving into a Knoll issue, there are a few different statutes that apply in State versus Knoll. North Carolina General Statute 15A-954 is basically when a motion to dismiss should be granted. So it says under 15A-954 A4, the court on the motion of the defendant must dismiss the charges stated in a criminal pleading if it determines that, again, number 4, subsection number 4, the defendant's constitutional rights have been flagrantly violated and there is such irreparable prejudice to the defendant's preparation of his case that there is no remedy but to dismiss the prosecution. It is important to remember, in a State versus Knoll grounds for dismissal, the only appropriate remedy is dismissal. If there's a State versus Knoll claim, the only appropriate ground is dismissal. So look at North Carolina General Statute 15A-954. Also be aware of NCGS 20-38.6, which is motions and district court procedure, that you must make the motion to dismiss prior to trial. Now, again, this may differ from one jurisdiction, one county to the next based on kind of local practice. I have seen several counties that have done suppression motions, for instance, during trial. So what would normally, or at least in some situations, be a reasonable suspicion or probable cause pre-trial motion, I have seen certain jurisdictions where they have just done that after arraigning the defendant. So again, this may differ a little bit from one county to the next, but typically under the 20-38.6, the motion must be made only prior to trial if you're going to make a motion to dismiss. So the important statutes as they relate to Knoll specifically are North Carolina General Statute 15A-511, which is on initial appearance, 15A-534.2, which is on the detention of impaired drivers, and 20-38.4, which is also on initial appearance, but specifically related to a DWI case. So these are the statutes that must be complied with in terms of a defendant's initial appearance. If there is a statutory violation, which is most of the time relatively easy to prove in Knoll, then you have to show how that leads to irreparable prejudice, which we're going to talk about a little bit later in the episode. So under 15A-511, the magistrate must inform the defendant, quote, of his right to communicate with counsel and friends, end quote. So that's part of the general framework for an initial appearance of any charge, okay, including DWI, but if any charge, 15A-511, the magistrate must inform the defendant of his right to communicate with counsel and friends. Now, specifically regarding the detention of impaired drivers, 15A-534.2 talks through when and how a magistrate is supposed to set conditions of release related to impaired drivers. In 15A-534.2A, it says this section may not be interpreted to impede a defendant's right to communicate with counsel and friends. So it reiterates that very fundamental right from 15A-511. But 15A-534.2 walks through when a person can be detained that has been charged with driving while impaired. So there has to be a right to a pretrial release when the judicial official either finds, one, that the defendant's physical and mental faculties are no longer impaired to the extent that he presents a danger of physical injury to himself or others, or two, a sober, responsible adult is willing and able to assume responsibility for the defendant until his physical and mental faculties are no longer impaired. So one of those two things has to be found. And in the detention of impaired driver form, there is a section in that detention of impaired driver form that is filled out by the magistrate, or at least it should be filled out by the magistrate to comply with the statute, as to if there is conditions of release of the defendant, why the person presents a danger to himself or others, which would typically be based on the person's physical condition. If a magistrate does not fill out that detention of impaired driver form, you may already have a statutory violation. If the magistrate fills out the form, but basically doesn't include any language as to why the defendant presents a dangerous situation to himself or others in that, so basically there's no language as to why the person is a danger, such as, defendant blew a .25, is barely able to stand up, is, continuously vomiting, whatever it might be. Again, maybe those aren't the facts of your particular case, but if there's no language in there as to why the defendant presents a risk, then just kind of signing the form at the bottom, but leaving that important kind of fill in the blank section blank is not going to be enough to comply with the statute. There have to be specific findings as to why the defendant presents that risk of physical injury to himself or others or property if he is going to be released. So look for those statutory violations. Finally, under 20-38.4, initial appearance specific to a DWI, it says that in determining whether there is probable cause to believe a person is impaired, the magistrate may review all alcohol screenings, chemical analysis, receive testimony from any law enforcement officer concerning impairment and the circumstances of the arrest, and observe the person arrested. So in terms of determining whether there's PC, that part is relevant. And then further and more important for a Knoll issue under subsection A4, so 20-38.4, subsection A4, the magistrate shall also, 1, inform the person in writing of the established procedure to have others appear at the jail to observe his condition or to administer an additional chemical analysis if the person is unable to make bond, and 2, require the person who is unable to make bond to list all persons he wishes to contact and telephone numbers on a form that sets forth the procedure for contacting the persons listed. A copy of this form shall be filed with the case. So again, in terms of the forms that you're looking for in a SHUC related to a DWI detention, you're looking for 3 forms. First of all, the bond paperwork, right? So the specific kind of blue sheet, at least in most of the counties I practice in, it's a blue piece of paper. The bond paperwork that the magistrate has filled out as to when the person shall be released which is generally in any criminal case, but again, also specifically to a DWI. Second, you're looking for the specific detention of impaired driver form, which would basically be the form outlining the reasons why the person presents a danger to themselves or to the community, and when they're going to be released, given that it's likely at some point that they will no longer be impaired. So this is a finding sheet specific to impaired drivers. And then finally, you'll see the contact form where the person has the is presented with the opportunity to list who they wish to contact by name and phone number. And it says under 20-38.4, A4, the magistrate shall include a copy of this form with the case file. So you have those three forms that you're looking for. And again, it's not just a question of are those forms actually in the file, but have they been correctly filled out? Did the defendant actually meaningfully get a chance, an opportunity to hear these rights from the magistrate and execute the rights? So if the person is given the form by the magistrate to list all the persons he wishes to contact by name and phone number, and he lists them out, but then is never given the opportunity of actually calling those individuals, then that's just a meaningless piece of paper. And that's not what is meant or conveyed by the statute. It's not enough to just allow the person to list who it is that he wishes to contact. There must be kind of a meaningful execution of those rights. So let's now jump into State versus Knoll itself. And one thing that is important to understand is that State versus Knoll uses a lot of the legal reasoning that is laid out in State versus Hill, a 1971 U.S. Supreme Court case. State versus Knoll is already a 30-year plus old case, decided in 1988. So it's got a lot of age on it. But it's important to note that State versus Knoll is the last time that the North Carolina Supreme Court has issued an opinion with regards to this post-release detention in the context of a DWI case. It's the North Carolina Supreme Court's last vocal announcement of what happens when there has been a flagrant violation of an individual's constitutional rights in the context of a DWI release. But it uses language and reasoning from State versus Hill. So let's just kind of walk through some of the language that is in State versus Hill. State versus Hill is at 277 NC 547 or 178 Southeastern 2nd 462. Again, that's a 1971 case. So I'm just going to read from excerpts from State versus Hill. And it's really important to kind of read through Hill in depth and kind of pull out the language. If you are going to make a State versus Knoll argument to the court, this is very kind of nitty-gritty case law analysis. If you're going to make a State versus Knoll claim in the courtroom, you need to have a really solid understanding of the statutes and case law that are at the crux of a Knoll issue. And then you have to be able to convey that extremely well, thoroughly to the court. This is one of the only times that at the district court level, I will typically prepare a memorandum of law supporting my motion to dismiss kind of prior to trial, so that I can get the law in front of the judge's eyes before we even called the first witness, before we've actually started the hearing. This is very complex legal analysis that has to go on if you're going to be successful in a Knoll violation. It is important for the defense to understand that the law is on our side when it comes to Knoll issues. And the reason why I think in many counties you don't have favorable outcomes coming in Knoll cases isn't because the law doesn't support a dismissal of the charge. It's because the judge does not understand State versus Knoll and what is required by State versus Knoll. That's our job. It's our job to communicate and educate the judge about State versus Knoll. It's a very complex area of DWI law and one that is not frequently presented, in my opinion, to judges in the courtroom. So they're not used to seeing these things. So you are going to have to really build the legal framework for the judge to see these kind of cases. So you're going to have to present a copy of each of the statutes that I just talked to you about. You're going to have to present a copy of State versus Hill, a copy of State versus Knoll, and then be prepared to go at length through the factual scenario that was going on in each of the Knoll cases, be able to argue the law from the statutes from Hill and from Knoll so that you can really build out the legal framework from which the judge is looking at the particular circumstances. So that's what we would be, that's what you need to do when it comes to making this argument in the courtroom. In State versus Hill, the Supreme Court stated, quote, "When one is taken into police custody for an offense in which intoxication is an essential element, time is of the essence. Intoxication does not last. Ordinarily, a drunken man will sleep it off in a few hours. Thus, if one accused of driving while intoxicated is to have witnesses for his defense, he must have access to his counsel, friends, relatives, or some disinterested person within a relatively short time after arrest. The statute says he is entitled to communicate with them immediately, and this is true whether he is arrested at 2 o'clock in the morning or 2 o'clock in the afternoon." So it's important to focus in on time is of the essence. Time is of the essence. The Supreme Court of North Carolina has noted that in impaired driving investigations and the ability of the defendant to defend himself, time is of the essence, right? Point to that in the Hill decision. The court went on to say, quote, "Defendant's guilt or innocence depends upon whether he is intoxicated at the time of his arrests. His condition then was the crucial and decisive fact to be proven. Permission to communicate with counsel and friends is of no avail in those who come to the jail in response to a prisoner's call and are not permitted to see for themselves whether he is intoxicated." In this actual situation, the right of a defendant to communicate with counsel and friends implies, at the very least, the right to have them see him, observe him, and examine him with reference to his alleged intoxication, end quote. Again, that was a long portion of the Hill decision, but it's important to communicate to the court that a defendant's guilt or innocence depends upon whether he is intoxicated at the time of his arrests. And it's important for him to have access to counsel and friends to be able to defend himself on that point. The court went on to say, and this is maybe the most important language in State versus Hill for the purposes of making a State versus Knoll motion to dismiss. Quote, "The evidence in this case will support no conclusion other than that the defendant was denied his constitutional and statutory right to communicate with both counsel and friends at a time when denial or deprived him of any opportunity to confront the state's witnesses with other testimony. Under these circumstances, to say that the denial was not prejudicial is to assume that which is incapable of proof." End quote. I'm going to read that last line again because this is your bread and butter when it comes to showing prejudice in your particular case. Under these circumstances, to say that the denial was not prejudicial is to assume that which is incapable of proof. And then finally, here's the last quote from the State versus Hill decision that I'll read today. Quote, before we could say that the defendant was not prejudiced by the refusal of the jailer to permit his attorney to see him, we would have to assume both the infallibility and credibility of the state's witnesses as well as the certitude of their test. I'm going to read that one again. We would have to assume both the infallibility and credibility of the state's witnesses as well as the certitude of their test. Court went on to say, even if the assumption be true in this case, it will not always be so. However, the rule we now formulate will be uniformly applicable hereafter. It may well be that here the criminal is to go free because the constable blundered. Notwithstanding, when an officer's blunder deprives the defendant of his only opportunity to obtain evidence which might prove his innocence, the state will not be heard to say that such evidence did not exist. Notwithstanding, when an officer's blunder deprives the defendant of his only opportunity to obtain evidence which might, that's not a broken recording. I'm repeating that for emphasis here, so make sure that you're awake. Which might prove his innocence, the state will not be heard to say that such evidence did not exist. The defendant has been deprived of a fundamental right which the Constitution guarantees to every person charged with crime. For that reason, the prosecution against him must be dismissed. So the importance of Hill in this framework of showing a state versus Knoll violation is to show, first of all, the importance of being able to get timely evidence for the defense in a DWI context, because impairment is fleeting. Being able to kind of show whether or not the person is impaired at the time is going to be evidence that needs to be immediately collected. If you're going to show the person is sober close to the time of driving, you need to get that evidence immediately. The defense has a right to get that evidence immediately. But also, it is the lost opportunity to collect evidence that is your prejudice. So many times in state versus Knoll cases in the courtroom, and I think that even more recent decisions from the Court of Appeals, not from the Supreme Court, more recent decisions from the Court of Appeals that deal with a Knoll issue really focus on what was the prejudice that was brought out by the defense. How did the defense prove that they were prejudiced? As you hear from the language of State versus Hill, prejudice in this case is basically showing what you can't prove the prejudice in a Knoll case. The Hill case says, under these circumstances, to say that the denial was not prejudicial is to assume that which is incapable of proof. It is the lost opportunity to confront the state's witnesses and their testimony with other testimony that is the prejudice. It's the lost opportunity. So what are you trying to prove in a Knoll case to show your client has been prejudiced? Simply the lost opportunity. You are not in a Knoll case trying to show that your client would have been able to go get 15 witnesses, and these are their names and the places that they live, all of whom would have said that your client was sober, and he would have gone to 3 different area hospitals and gotten independent blood test as well as a urine analysis. You're not required nor expected to show that. Now, many judges think that you should. And if they think that, it's because you haven't appropriately explained what State versus Knoll and State versus Hill require in showing irreparable prejudice. In this context, to show irreparable prejudice, you are simply required to show that there was a lost opportunity on your client's behalf to get independent witnesses and to be able to get their own independent testing. It is impossible to show what they actually would have done had they been released. Had they been released and there was no statutory violation in terms of their release, you cannot show. It is that which is incapable of proof to show what they actually would have done. So what are you required to show prejudice? That there was a lost opportunity to do that. That's it. Don't make it more complicated than it needs to be. There's enough already complicated with these. What are you required to show in order to show a Knoll violation? First of all, that there was a statutory violation in regards to the defendant's release. And then secondly, that there was a lost opportunity to collect evidence. That's how you prove irreparable prejudice, was showing the lost opportunity. So make sure you do not communicate to the judge, nor do you let the DA that's involved communicate to the judge that you are required to prove prejudice. Prove what your client would have done if they had been released early, timely released. That's not what you're required to show. You're required to show that there was a lost opportunity to collect evidence. If you show the lost opportunity, that's all you got to show. And as we get into the facts of the Knoll case, this is going to become more apparent. I think that this will, for anybody that has kind of not done a deep dive in Knoll, but has some idea of what Knoll stands for, the facts in Knoll and the other two cases in that decision are, I think, going to be kind of shocking to you in terms of what the court found was enough for a dismissal to be granted. So let's go ahead and dive into the three cases of State versus Knoll. So these are the facts that I use in my legal memorandum when I file a memo in support of a Knoll motion to dismiss. So here are the facts from the actual State versus Knoll case. In Knoll, the defendant was arrested for DWI at 1:15 in the afternoon. An intoxilizer test was done a little over an hour later at 2:31, and the defendant blew a .30. Yes, .30, nearly 4 times the legal limit. He was taken in front of a magistrate between 4 and 5 p.m., and a $300 secure bond was set. Knoll spoke by telephone with his father around 5 o'clock p.m., and Knoll's father said his son was, quote, oriented and coherent and not noticeably impaired in either his manner of speech or in the substance of what he said, end quote. So he spoke with his dad a couple of hours after the breath test. Knoll's father did not post bond until later that night because he was told by phone by the magistrate that his son would not be released until 11 p.m. Knoll's father came back at about 11 p.m. to have his son released, and therefore Knoll's total time in custody was approximately 10 hours. Now, immediately important in this case, is to point out two things from this particular situation. Number one, the person blew a .30. Knoll blew a .30. If you have a client that has a low alcohol concentration, but even up to a .20, you can say the alcohol concentration does not matter. In Knoll blew a .30. Yes, really, a .30. Okay, so that's number one. The second thing to note is that he had a conversation with his father where his father indicated that he was oriented and coherent and he was not noticeably impaired in either his manner of speech, so he didn't have any slurred speech, nor in the substance of what he said. Why is that important? because what the state will oftentimes try to do in these cases is basically say, well, Judge, he actually did get to talk to his family member on the phone during this time frame. He just wasn't let out of jail, but they were able to, come in and testify to the fact that they had a phone conversation with him and he sounded clear. So the defense can't show irreparable prejudice. No. In Knoll, the actual named case in State versus Knoll, in Knoll, the defendant was able to talk to his dad. His dad could have come in and said, based on the phone conversation, I would have thought he was sober, and that's not sufficient. Because of the fact that he wasn't released to go get his own independent witnesses and his own independent test, that is enough of a violation to grant a dismissal. So the fact that he had communicated with his dad during that time frame wasn't enough to overcome the irreparable prejudice of the lost opportunity to get whatever the heck evidence he wanted to get. So don't let the state use a phone call that's made during that time frame where the person actually talks to another individual to be able to bypass the fact that they did not comply with the statutes and he should have been released earlier. All right, case number 2, State versus Warren. In State versus Warren, defendant Warren was stopped at approximately 10:11 p.m. After being arrested for DWI. An intoxilizer test was administered at 11:08 p.m. and the defendant blew a .25, another high blow. The magistrate set a $500 secured bond. 2 individuals arrived at the jail between 11 p.m. and 11:30 p.m. and had the opportunity to speak with the defendant in person and observe his condition. Think about that. I'm going to go through this again in just a second. 2 individuals arrived at the jail between 11 p.m. and 11:30 and had the opportunity to speak with the defendant in person and observe his condition. That is a crazy fact. We're going to talk about why that's a crazy fact, but that is a crazy fact that you have to bring out in a Knoll hearing. They were told that the defendant would not be released until 6 o'clock in the morning. One of these individuals then came back to the jail at around 8 p.m. and posted the defendant's bond. Warren's time in custody between the stop and his release was approximately 10 hours. So just like Knoll, time between stop and release was approximately 10 hours in this case. Here is the mind-blowing fact of this particular situation and why all the defense has to show is lost opportunity. In this case, the defendant actually had 2 people come to the jail, see him in person, speak with him in person, and that was not enough to cure the irreparable prejudice created by his lack of release. That's crazy. Okay, so if you're talking to a judge or you hear the DA basically say, well, we can't tell if this person would have actually even gone out and had anybody come see him, right? Be able to testify about him. It does not matter. In the Warren case, the person can actually show, the state could actually say, well, Judge, he had 2 people come into the jail, talk to him, be able to observe his condition. And so where's the prejudice, Judge? These people came into the jail. They were able to speak with him. They were able to observe his conduct. There's no prejudice. I mean, he was able to get his own witnesses present in the jail with him. That seems actually, if you think about it, like a pretty logical argument. I mean, just to give, the prosecutor a little bit of a little bit of like a reasonable kind of argument here on this particular front. That's a pretty reasonable argument, but the court says, nope, doesn't matter. If you aren't going to be given the opportunity to go get whatever evidence that you want, it doesn't matter that there was actual evidence that the defense could have presented, in this case of 2 individuals that got to speak to him and observe his condition in person. That's not enough. It's not enough. If that's not enough, you really are going to have a hard time as the state being able to show this. And that's why you need to walk through these facts when you're making a state versus Knoll argument, because they are incredible facts. Judge, this person, Warren, blew a .25. He had 2 witnesses come down to the jail, see him, talk with him, speak with him, observe him in person. And yet the court found that's still not enough, because he wasn't released in a timely fashion, that there was still irreparable prejudice created by the lost opportunity on Warren's situation to go get even further witnesses and to get his own test. Boom. That's a crazy factual scenario. Finally, we have State versus Hicks. Another Wake County case. I think all 3 of these are Wake County, if I'm not mistaken, but I could be wrong. One of them might not be Wake, but defendant Hicks was stopped on April 28th, 1984 and arrested for DWI at 12:45 a.m. He blew a .18. All 3 of these cases are .15 plus cases. 0.18, 0.25, and 0.30. These are high blow cases, okay? So the fact that the blow was high doesn't make any difference in this situation. I can remember the first time that I ever had a state versus Knoll argument, the DA in my case, I think my client actually blew a .18. It was either 0.18 or 0.19. And the DA was saying, Judge, I mean, what's the difference here? Like, this person blew a 0.18. I mean, what's the difference? And I, was able to use these 3 cases. Judge, it doesn't matter what the blow was. In Hicks, it was a 0.18. Warren, it's a 0.25. Knoll, it's a 0.30. It doesn't matter what the blow is. It doesn't make any difference in terms of whether the defendant's constitutional rights have been irreparably prejudiced. So in Hicks, he's arrested at 12:45 a.m. He blows a .18, and he was allowed to call his wife from jail about 1:30. So about 45 minutes after the arrest, he's able to call his wife. Defendant's bond was set at $200, and despite the fact that defendant had over $2,000 on his person, he was not released until 6 a.m. Hicks's total time in custody between his stop and his release was 5 hours and 15 minutes. In State versus Hicks, the court found that if the defendant had been released, he could have called a taxi to get home. So even if the defendant's wife had not been able to come and get him, he could have called a taxi, been able to go wherever he needed to go, to have other people observe his condition, to have a third party, a neutral third party, observe his condition. So whether or not there was somebody there to even pick him up didn't make any difference, because they said, well, he could have got a taxi, right, to get to go find his own witnesses or to get his own test. This is also a really good case if you have a person that is in custody that has the amount of money necessary to cover their bond on the person, because the Hicks, the court kind of specifically in the Hicks set of facts said, he had the $2,000 on his person to post the bond. So if that's an issue in your particular case, point to that. But again, in 2 of these cases, you had the defendant able to speak with somebody by phone, State versus Knoll and State versus Hicks. In the State versus Warren case, you had the ability to see the person in person. There was witnesses that arrived that were able to see Warren in person. None of that made any difference. None of that made any difference. So in all 3 cases, State versus Knoll, State versus Warren, and State versus Hicks, the trial court found that there was a violation that created irreparable prejudice that should result in dismissal. The Court of Appeals basically reversed all 3 of those rulings. And again, if you hear the kind of court pointing this, Court of Appeals reversed based on the fact that there was not irreparable prejudice created in these circumstances. That there was not irreparable prejudice. That's why the Court of Appeals in the State versus Knoll cases reversed. The Supreme Court said, nope, Court of Appeals, you got it wrong because you didn't understand, Court of Appeals, what irreparable prejudice is in the context of Knoll. What is irreparable prejudice? It is simply the lost opportunity to go get one's own independent witnesses or one's independent chemical test. That's it. That is absolutely it in terms of being able to show irreparable prejudice. So to kind of conclude with this, we're going to basically kind of just read the language that is at the end of State versus Knoll. So this is basically from the second to last paragraph of the Knoll decision. Quote, each defendant's confinement in jail indeed came during the crucial period in which he could have gathered evidence in his behalf by having friends and family observe him and form opinions as to his condition following arrest. This opportunity to gather evidence and to prepare a case in his own defense was lost to each defendant as a direct result of a lack of information during processing as to numerous important rights and because of the commitment to jail. The lost opportunities, okay, here we go. The lost opportunities in all three cases to secure independent proof of sobriety and the lost chance in one of these cases, so in only one of these cases that they find this lost opportunity, but the lost chance in one of these cases to secure a second test for blood alcohol content constitute prejudice to the defendants in these cases. That the deprivations occurred through inadvertence rather than wrongful purpose of the magistrate renders them no less prejudicial. That language is defense language right there. And they basically had just gone through in that decision why the Court of Appeals analysis of the defendants not proving the prejudice was incorrect. Because what the Supreme Court of North Carolina has said is that in a Knoll violation case, what the defendant has to prove is the lost opportunity to secure independent proof of sobriety, either through witnesses or chemical testing, and that lost opportunity constitutes irreparable prejudice. Finally, the court says, it doesn't matter if the magistrate was acting with an evil mind, right, with not intentionally not conveying rights to the defendant, which is never going to happen. Magistrates are trying to do their job, some better than others, but there's nobody sitting back there saying, I'm not going to fill out a detention of impaired driver form because I just hate this person sitting across from me. It's always going to be through inadvertence that the magistrate screws up on these kind of cases. But what the Supreme Court says is it doesn't matter that it's an inadvertent mistake by the magistrate to not grant one of the statutory rights that is allowed to the defendant. It doesn't matter if it's inadvertence or intentional. If there is a lost opportunity to get one's own independent tests or get in front of an independent witness, then the defendant has shown irreparable prejudice. So to conclude with this, I think this is the most important thing when it comes to these kind of cases. You have to lay out this legal framework to the judge. You have to lay out the statutes. You have to lay out the case law. You have to show the similarity in facts or the better facts that you have in your particular situation versus the facts that were present in either State versus Knoll, State versus Warren, or State versus Hicks. And then you have to pound into the judge's mind, because this is the correct law, the correct legal analysis. You have to pound into the judge's mind that you have to show one thing in terms of showing prejudice in this case, and that is the lost opportunity to collect evidence. You do not need to show anything in terms of what would have actually happened had your client been released from custody. That is a guessing game that the state of North Carolina is not going to get into, that the courts of North Carolina are not going to get into. as shown by the Knoll decision. What do you have to show? Lost opportunity. So make sure that you pound lost opportunity, hammer lost opportunity, push lost opportunity, talk about lost opportunity until you're blue in the face, because that is where Knoll cases are won and lost. Again, on next week's episode, we'll have Nathan Earwood on the podcast to kind of talk through how these issues practically play out, how you can kind of argue these things practically in front of the judge in the courtroom. And I look forward to seeing you next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.